Sir, thank you very much.
Mahtab. Mahtab.
Sir?
Huh?
Oh, thank you. I'll just come.
You gave your name, na?
I was waiting for my predecessor from JDU to speak, but thank you, sir.
Okay.
This reminds me of the deliberation that we had 20 years ago or 22 years ago, when the then Deputy Prime Minister, Mr. L.K. Advani, being the Home Minister, had moved a bill, which was an ordinance by that time, Prevention of Terrorist Ordinance, POTO. Subsequently, it became POTA. And that time, Lok Sabha, of course, passed it in a hurry. It got stuck up in Rajya Sabha. And then subsequently, for the second time, the joint session was called to pass the bill. And in Central Hall, we all debated again on this bill. That has reminded me. I'll come to that aspect a little later. But I would say the Central Procedure Identification Bill 2022 intends to replace the Identification of Prisoners Act 1920. This bill enables the police to collect fingerprints, photographs, iris scans, and a range of biological identity samples from individuals. If it authorizes the National Crime Record Bureau to create a central repository of this evidence and share it with law enforcement agencies. On the face of it, this 2022 bill appears to be broader, more modern version of its colonial predecessor. But is such a law too intrusive? That is the question which is being debated here in this House. Is such intrusion consistent with the Constitution? These are the two major questions that which needs to be discussed. Crime prevention, sir, is a core function of the government. But to be constitutionally valid, the law must be validly enacted, serve a legitimate purpose, and any curtailment of fundamental rights for this purpose must not be excessive. This is a delicate balance act, usually achieved by narrowing the scope of intrusive provisions and introducing safeguards to prevent abuse. As intrusion into an individual's right increases to combat crime, laws must put in place stronger safeguards to prevent abuse. Curiously, this bill has gone the other way. It allows the police to collect samples not only from convicts, but also those arrested or even detained under any preventive detention law. This blanket provision between local gunda detained when a dignitary is visiting or those convicted by terror offences. More worryingly, even if a person has never been arrested in connection with an ongoing investigation, a magistrate can order their samples to be collected. This has the potential to create a comprehensive profile of all citizens in this country. Is this what the government wants? We have discussed today, my predecessors have discussed about data protection. A bill is pending before the government. The joint committee has already given its report. The DNA bill, already the standing committee has given its report to the government. It is still pending. These two major bills, if it would have come to the House to be passed, then it would have been easier for us to accept the provisions that are there in this bill. I think the government may think over it. Back in 1980, sir, the Law Commission of India in its 87th report and the Supreme Court in a judgment titled State of Uttar Pradesh versus Ram Babu Mishra had nearly simultaneously suggested the need to amend the statute. There is no doubt about it. However, we find devil in the details, with three expansions in the power of the state surveillance. First, the definition of measurement is not restricted to taking measurements. It also includes analysis. The definition now states iris and retina scan, physical, biological samples and their analysis, behavioral attributes, including signature. This definition is nebulous and vague. It goes beyond the scope of law, which is designed for taking measurements. The definition of physical and biological sample, and I quote, physical and biological sample, is not provided in the definition provision of this bill, and an arguably extend to the collection of DNA samples. A bill is there since 2019. Standing committee has raised concerns about privacy and profiling. The second area of expansion of surveillance concerns from whom such measurement can be gathered. The existing law permits data capture by police and prison officers, either from persons convicted or persons arrested for offences punishable with a minimum of 1 year's imprisonment. Parallel powers are granted to the judges or the judiciary, who can order in aid of investigation. While judicial power is left undisturbed, it is the powers of the police and prison officials that are being widened in this bill. Through this bill, it is expanded to all persons who are placed under arrest in a case. The bill contains muddled language. Mark my words, it contains muddled language stating that a person, and I quote, may not be obliged to allow taking of his biological samples. Repeatedly, I think Nishikant Dubey will agree with me. He has heard me saying this many a time. English is a very funny language. And if you read it 3 times, you get 3 definitions, especially the draft, that 3 definitions. And especially the draft that is done by our Department of Legislature, what is it called? जो ड्राफ्ट बनाते हैं लीगल अफेयर्स की, ये उसी हिसाब से एक व्यवस्था है. और मैं बताना चाहता हूं कि ये जो प्रोविजन लिखा गया है, may not be obliged to allow taking of his biological samples, ये दोनों तरफ से ये होगा. और ये this is in surface offers a choice to a person to refuse. However, the words may not be obliged may also be read to offer discretion onto a police officer to confer such a choice. This choice, and I say, may not be truly voluntary when there is absence of accountability in our police practices. Sir, third area of concern is the database of the measurement which are gathered and would be kept for 75 years and to be destroyed earlier if the person is discharged or acquitted. I am of the belief that the concern expressed in this House over privacy and safety of the data is significant. Such practices that involve the collection, storage, and destruction of vital details of a personal nature ought to be introduced only after a strong data protection law. Sir, India has a long history of state governments, because ultimately this bill, when it becomes an act, will be implemented by the state police. At very few instances, the central government will be enforcing this bill when it becomes an act. It will be enacted by the state police. And we all know, most of us have the experience, police departments in the state hound opponents. The bill needs to provide enough checks and balances to prevent abuse of its provision by police to harass or implicate innocent persons. Neither it dwells on unauthorized access to stored data or misuse of data by the police. Lastly, sir, I would draw the attention of the House to the bill where it is mentioned, and I quote, any other examination referred to in section 53 and 53A of Criminal Procedure Code, unquote. These are the two provisions in CRPC. In turn, is very loosely worded. If you go through, sir, you yourself very much aware about the legal terminology. What does it say? Such other tests which a registered medical practitioner thinks necessary. This is the word. And you are giving so much of wide scope to the police officer, to the registered medical practitioner to allow the person to do the mapping. I conclude by saying this, sir, quoting a small paragraph from a very famous book that I had quoted long before, I think 22 years before, when the POTA or POTO ordinance was being debated in the joint session of both the houses. It was the best of times. It was the worst of times. It was the age of wisdom. It was the age of foolishness. It was the season of light. It was the season of darkness. It was the spring of hope. It was the winter of despair. We were all going directly to heaven. We were all going the other way. These were the first few lines of a famous novel, Tale of Two Cities, describing of 1789. Are we in that situation today? Something is not dark or white. It's a mixture. Yes, we are fighting against terrorists. We want to control them. But at the same time, are we doing something which will protect innocent citizens? There, actually, the crux of the issue lies. We have to bring a balance. And here in this bill, that balance is lacking. Thank you, sir.
Srimati Supriya Sole.
Thank you, sir. Sir, I